One of the most critical components, if not the single most critical component, to determining if a litigation funder will invest in your case is due diligence that is performed to assess the merits of the claim and what the funder believes the strengths of the claim will be. There are many factors that go into the due diligence process, and some finance companies may look at specific factors more than others. But more than likely, all litigation finance companies will need information from the plaintiff's attorney to conduct due diligence. This information could include a copy of the complaint, copies of depositions, or, if the case is on appeal, then possibly copies of documents or evidence from the trial court. The major problem with all of these documents is that they would usually be protected by attorney-client privilege. However, as litigation finance continues to grow as an industry, an exception to the normal waiver rules for attorney-client privilege has developed. That exception is called the common interest doctrine. Courts often define the common interest doctrine as an exemption from normal waiver rules that apply when a third party to whom privileged information is disclosed shares a common legal interest with the party that made the disclosure. It is important that this is characterized as an exemption to the waiver rules. This means that the third-party funder is not entitled to a privilege, but rather, attorney-client privilege is not waived if information is shared with a third party that has a common interest. This is different than work product privilege. Work product privilege protects materials prepared for pending litigation. A client can implicitly waive work product privilege by giving information to a third party. Work product privilege is meant to give even broader protection than attorney-client privilege. While attorney-client privilege, common interest doctrine, and work product privilege may seem all a little confusing at first, they each play a vital role in lawsuits. Without these doctrines, litigation funders would not be able to do their jobs, and lawsuits would look a lot different because no information would be off limits to the adverse party. If you need help with litigation funding, call or email me today.